Welcome to this medicine masterclass in which we will be discussing do not attempt cardiopulmonary resuscitation orders. Do not attempt resuscitation orders are very important documents which guide treatment of patients. We will explain the clinical rationale, the Human Rights Acts and DNR or DNCPR, the role of advanced directives, what to do when patients lack capacity, the guidance from the Resuscitation Council, and the ethical considerations. So do not attempt cardiopulmonary resuscitation has replaced the previous DNR, do not attempt resuscitation, to be specific about the intervention that is held, which is cardiopulmonary resuscitation. When assessing whether attempting CPR may benefit or be in the best interest of a person who lacks capacity, decision makers must not be influenced by their personal views about living with a particular condition or disability. They must take into account all of the relevant factors, particularly the patient's own views about what would be an acceptable level of recovery where these can be ascertained. Patients have no legal right to treatment that is clinically inappropriate. Sometimes patients or those close to them will try to demand CPR in a situation where this is clinically inappropriate. If the healthcare team has a good reason to believe that CPR will not restart the heart and breathing, this should be explained in a sensitive yet unambiguous way. The DNR and the Human Rights Act 1998. Article 2 states that provisions particularly relevant to decisions about attempting CPR include the right to life. Article 3 states the right to be free from inhuman or degrading treatment. Article 8 emphasizes the right to respect for privacy and family life. Article 10 contains information relating to the right to freedom of expression, which includes the right to hold options and to receive information. Article 14 concerns the right to be free from discriminatory practice in respect to these rights. CPR must not be attempted if it is contrary to a valid and applicable advance directive. Advance directives are legally binding on the healthcare team if the patient is 18 years old and above and they had capacity when the decision was made, the decision is in writing, signed and witnessed and dated, and it includes a statement that the advance decision is to apply even if the person's life is at risk. The advance decision has not been withdrawn subsequently, and the person has not, since the advance decision, appointed a welfare attorney to make decisions about CPR on their behalf. The circumstances that have arisen must match those envisaged in the advance decision. In England and Wales, the Mental Capacity Act 2005 requires consultation with an independent mental capacity advocate regarding all decisions made by an NHS body about serious medical treatment where a patient lacks capacity and has nobody to speak on their behalf. If a CPR decision is needed when an IMCA is not available, the decision should be made and the reasons for it documented in the health record, and an IMCA should be consulted at the first available opportunity. An IMCA does not have the power to make a decision about CPR, but must be consulted by the clinician responsible for the patient's care as part of the determination of that patient's best interests. The ethical issues involved in do not attempt cardiopulmonary resuscitation include autonomy. A person over 18 with capacity should voluntarily be able to consent in an informed manner to what happens to them. This is a right of a human being protected by the Human Rights Act and the European Court of Human Rights, Article 2 and 8. If a person is able to accept the risks of a poor outcome, fractured ribs, potential indignity, then that should be supported. And can doctors really predict, even on an evidence based, whether someone will or will not survive a CPR event? Beneficence: to do a good thing is to end suffering. To try to bring back a human being from the brink of death is a good thing to help them live longer. Non-maleficence is to do no harm. We have to think about the harm the body will be put through and including the trauma of multiple cannulation sites, multiple blood gases, and the whole ordeal that cardiopulmonary resuscitation entails, and see whether that is something that the patient would want. A Kant-based deontological approach is that the act itself is good and virtuous, and an Aristotelian view would be to do what is in the best interest and what is the most virtuous thing to do for the patient. And finally, justice, the allocation of resources. An immense amount of resources required to sustain a life in extremis. It involves the on-call teams, the intensive care, high dependency care teams, and prolonged subsequent ward admissions. And if someone is not going to have a good outcome or a very poor outcome, could this resource be offered to someone who's critically ill? Note that the withdrawal of CPR is not intended to speed up death, but is intended that is not in the best interest of the patient. Another thing is to think about the opportunity cost, the amount of lives that could be saved with the amount going in to sustain somebody who is in cardiac arrest. So we have covered the clinical rationale behind resuscitation decisions, the Human Rights Act, advanced directives, what to do when patients lack capacity, addressed some of the Resuscitation Council guidance, and thought about some of the ethical considerations. Thank you for attending this medicine masterclass.